Okay, People versus Kyle, People versus Alexis Bradley, case number 245301.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Alexis Bradley.
Thompson, can you tell me the status of this case here today?
Your Honor, I had good contact with my client through, she had an appointment in my office May 22nd. After that, she apparently moved. Phone was, shut off or changed or whatever. Wasn't able to reach her after May 22nd. She got a call from the place she had been living that, she wasn't there anymore in terms of where her mail was going. And then she did appear today, apparently, since that, mail has found its way to her from her former address. And I think Mr. Guerin was he would be prepared to address this. I think Ms. Koch had indicated she intended to join these cases for trial. I don't believe there's an order doing so. It alleges one transaction in common and then one transaction that only involves Mr. Pertel. So I'm not as prepared as I wish I was.
Ms. Bradley, come up here, please. All right, is there a reason why you haven't been in touch with your attorney since May?
My phone was completely broken and I had no access to a cell phone or a home phone to contact
Can
me.
you take your hands in your pocket?
Yeah, sorry.
Okay, so you're telling me since May you haven't made a phone call to anybody?
Correct.
I don't believe that. I don't believe that since May you haven't made a single phone call in your life. Is that what you're telling me?
No, Your Honor. I just recently got a new phone.
Just recent. So
Just
between
recent.
May and just recently, you didn't make a single phone call to a single person.
Correct.
I don't believe that. I don't think in today's society, anybody's going for 5 months without making a phone call.
I mean, I've done it before.
Okay. You're aware that you have this charge here, which is a 15-year felony against you?
Yes, Your Honor.
You didn't think it was important for you to find a way to talk to your attorney about it?
I believe that I should have gotten a hold of him, but I haven't because I did not have access to a phone.
All right. Thompson?
Yeah, another complicating factor. I understand my client did give birth on October 12th, 2024. So I think that explains some of her status, but of course, the point still stands. But I want the court to know that she did just give birth.
Okay. And I mean, in my mind, that make me even more anxious to talk to my lawyer about what was going on with the case. Be that as it may, Ms. Koch, we have trial dates set in this case for December. We have December 9th, 10th, 11th.
Yes, it was my understanding that they were going to go together. And I've always thought they were joined together, so I'm trying to find, it says they're stacked together, but it doesn't say they're combined together, is what the court order says.
Okay.
But they do all involve one transaction.
Yeah, and I don't want to speak for Mr. Guerin. We have discussed the case, obviously, and I know he has some investigation he hasn't been able to complete because of a similar situation. So, and again, the cases aren't joined at this point.
Are you going to be objecting on behalf of your client to join?
That probably depends on the trial date.
Well, right now, one of these is going to go starting December 9th or whatever.
Yes.
So I probably would be starting with the one that was charged first, which would be, it looks like Mr. Pertel's case. 530.
So I would object.
To join her.
Yes.
Okay.
Given where I'm at, I think that's what I have to do to protect my client's interest.
All right. Mr. Germer, you're representing Mr. Pertel?
Yes, if I can have Mr. Patel come up to it.
Yeah, Mr. Pertel. You might as well address these together. So we'll go on the record in People versus Pertel as well, case number 245300. Mr. Germer, are you going to be objecting to a joinder?
given that, well, first, Judge, I would ask that the trial be adjourned. Some same reasons as Mr. Thompson indicated. I've had no contact with my client since May. He was supposed to set a time with me. We got some funding for some additional investigatory things that needed to be done, and then the phone number that I had for my client didn't work. He indicated to me that they just got a number this morning, and he just got my number from the clerk this morning, so he hasn't been able to talk to me, call me, or do anything with this matter. As Mr. Thompson indicated, he is the father of the child that they gave birth to in October. They're thinking about it last common. And I'm just not ready for trial at this point, Judge. Normally that is not the case. I'm always prepared and ready. We diligently work these matters, especially when we have trial dates. That's just not the case in this matter. And I would again state for the record, without that investigatory tools that I need to assist my client by way of his defense, this could create an appellate issue. But again, it's not Ms. Koch's fault, but I don't even want to say it's the defense's fault, but I know Mr. Patel has just maintained very minimal, almost no contact. And I think he still is deserving of that defense and exploring that. So once we have that, I think that answers some of the questions as it relates to joint as well. And again, that investigation may resolve the case by plea as well. But without having that crucial evidence and that piece for the defense, my hands are essentially tied.
Okay. Mr. Patel, why haven't you been in touch with your attorney?
I just got his number today from the clerk. Didn't get a chance to call him due to no Wi-Fi on the phone.
Okay, well, here's where we're at. All right, this one was bound over in April. Miss Bradley's case was bound over in May, beginning of May. The court set the trial dates like in July. Trial dates were mailed out. Yeah, July 29th. So I understand that the attorneys may not be ready. I know that's not either of your faults.
I take all full
Yeah,
responsibility.
but Mr. Patel and Miss Bradley have choices in their lives. One of those choices, and regardless of whether they had phones or not, to not make contact with either of you. So any prejudice that they're going to suffer because of that is the result of their own delay. I'm not going to delay cases that were bound over in April further. They haven't given me a good reason, in my view, for not contacting either of you. Again, I think it's absolutely ridiculous. Today's age of technology for two people to claim that they had no way to contact their lawyers between May and now. It's just ridiculous. So I don't accept that as a valid reason for not talking to your attorneys. I don't find that that's a valid reason to delay your trials. Again, the prosecutor has an interest in the speedy trial just as much as the defendants do. And they made, again, choices to not contact their attorneys. And I don't have any faith or belief based on what either of them are telling me here today, that if I delay this for another 2 months or 4 months or 6 months, that they're going to do anything more than what they've done so far in terms of cooperating. So I don't find that a delay in this case is going to serve the end of justice, because I don't have any confidence that either is going to pursue their defense any more vigorously than they have since the cases were found over in April. So what that leaves counsel with is doing the best you can with what you have. Right now, the trials are both set to begin on December 9th. Based on the order that they were filed, Mr. Patel's trial will go first. I don't think we've ever had a motion or a hearing on consolidation. So Ms. Koch, to the extent that you want to do that, I'm going to give you 14 days to get that motion filed. Otherwise, we're going to proceed with Mr. Patel's trial on December 9th, and then because they are stacked, have to move Mr. Patel's trial out to Mr. Germer, you'll have to do the best you can with what your clients are deciding to do in terms of cooperation for your clients. Ms. Koch, anything further from you to address?
No,
Thompson or Mr. Gerber?
I guess I would just indicate now that we're in communication, I mean, I would be open to talk to the prosecutor in the court about where we're at.
And I'll set each of these for one final status conference on the motion date in December, in case there are any resolutions that either you're able to address. Other than that, Mr. Pertel, I'm going to recommend that you talk to your lawyer. You're going to trial on December 9th, unless there's a resolution prior to that. So if you have any interest in helping your attorney put on a defense for you, you're communicating with your attorney. But that's up to you. If you decide not to, we're going to go forward anyway. If you don't appear either for the last hearing in December or the trial, the court will issue a bench warrant for your arrest and be in the jail until we complete the trial. Okay?
I always appear, Your Honor. I never missed a court date ever.
Good. Well, let's keep it that way. Ms. Bradley, you also need to stay in touch with your attorney. I'm going to schedule your case for a hearing in December as well. So you need to make sure that you stay in touch with Mr. Thompson.
Yes.
We need to get confirmed addresses for each of you here today. So Ms. Bradley, can you tell us an address we can be reached?
103 Crestwood Drive, Millen, Michigan. That is my mailing address.
We send mail to that address and you can get it.
Yes.
And Mr. Pertel.
103 Crestwood Drive, Grand, Michigan.
Okay, same question for you if we send mail
Yeah.
to that address. You'll receive it?
Yeah.
Okay. All right, very good. Thank you. That's all for today. Our next hearing is 1:45. We'll take a short recess to come back on record. Okay, Mr. Bullock, if you can come forward, please. This is People versus Bullock, case number 245343. If I could have counsel for your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, on behalf of defendant Jason Bull. Your Honor, this is our first status conference with Your Honor. We did run a prelim, it was found over. Mr. Bull, I think there'd be benefit to 30 more days of talking about a possibility. If we don't get that done, we'd be ready to try it. It's a pretty straightforward case. There's body cam video that shows the scene. It's really a judgment call for the finder of fact, and they're requesting a jury trial at this point.
Ms. Coke, have there been any plea offers?
Yes, we discussed a plea. They rejected the plea, ran the preliminary examination. We have not discussed a plea since they ran the preliminary examination.
Are you anticipating a different plea offer or a new plea offer?
Yes, the plea offer will be RNO, HAB 2.
All right, so Mr. Thompson, I'll set this first status conference and plea hearing in about 30 days. So Mr. Ball, between now and then, you need to make sure that you discuss that with Mr. Thompson when we're here for the next hearing. I'll be asking you for a final decision about whether you want to proceed with that offer or proceed with trial, okay?
Yes, sir.
Did you have any questions at all?
No, sir.
Ms. Coke, anything further tonight?
No, thank you, Your Honor.
Mr. Thompson?
Nothing further, Mr. Bull. It's been a good communication, and his mailing address should still be good.
Okay, thank you.
Okay.
Mr. Nichols and Ms. McGregor, I know we're a few minutes early. Are you both ready to proceed?
Well, I'm ready, but my client's not here yet.
Okay.
I did have communication with her today. She confirmed she was.
Okay, I'd rather wait than to make sure that she's present, so we'll
Okay.
take a recess and we'll come back.
Okay.
in 5 to 10 minutes. Your name is Mr. Marvin, is that correct?
Michael Jack Marvin, yes, Your Honor.
Okay, so this is People versus Michael Marvin, case number 245339. Record to reflect that Mr. Marvin is present here in the courtroom today.
Sierra Coke on behalf of the people.
So, Mr. Marvin, it looks like this is your first appearance here in the circuit court. You're here without an attorney. You understand that you do have the right to have a lawyer?
Yes, Your Honor.
Okay, and you understand that if you can't afford a lawyer, one would be appointed for you at public expense?
Yes, Your Honor.
Did you wish to request a court-appointed attorney?
No,
You want to represent yourself?
correct, Your Honor.
So I'm going to go through some things with you with regard to that, okay?
Yes, Your
First of all, have you ever represented yourself in court before?
Honor. No, Your Honor.
Have you ever received any legal training or have you had any experience?
No, Your
Honor. Have you ever, do you have any kind of a legal degree or other degree?
No, Your Honor.
Okay. So I want to make sure that you understand that without any of that kind of training or experience, that there's certain risks that go with representing yourself. There are issues regarding procedure in the law that you might not know about, and you might not follow some of the rules that you're required to follow, and that could hurt your case. Also, things about the substance of the law. In other words, there might be some legal defenses or arguments that could be made on your behalf that you might not know about without having an attorney to advise you on those things. Also, the consequences, you know, what kind of penalties that you could face and what your options might be. An attorney could help advise you of all of those things. And so without having that kind of advice, you could have a worse outcome in your case. Do you understand all of that?
Yes, Your Honor.
Knowing all of those things, did you still want to represent yourself?
Yes, Your Honor.
So I find for the purposes of today's hearing that your waiver is knowing and voluntary and unequivocal. In other words, you're sure that that's what you want to do?
Yes, Your Honor.
Okay. So all of that being said, Ms. Koch, have you had any discussions with Mr. Marvin? Have there been any plea offers?
Yes, to both of those. The plea offer was to the drunk driving third, dismiss the additional, the RNOs and the open intact charges. Mr. Marvin wants to have a trial. I talk to Mr. Marvin at least once, sometimes twice a week, maybe more. And he is considering filing a suppression motion. I sent him the blank SCAO motion, told him, you know, I can't give him legal advice, but procedurally, this is how you file a motion if you want to. We talked about, he wants to have his wife come in and testify that he has a habit of driving places and then getting drunk at those places, and she comes and picks him up. I advised him if he goes down that road at trial, that I'm going to ask that his prior drunk drivings come in. They would not come in otherwise. So, you know, opening the door could be bad for him, and he should have an attorney. I advise him regularly that he should have an attorney, but he doesn't want to. He also discussed the reason marijuana was in his system. I told him that's probably not relevant, and I would object if he tried to bring that up in trial, because it doesn't really matter why he had the marijuana in his system. But we went over those issues. I think we're ready for trial. I'd ask the court to set the trial, and if he files a suppression motion, we can run it. We already ran a preliminary examination, and I think he did a request to get the transcript today, so we can go from there.
Okay, and just because so this is based on intoxication involving alcohol, that.
Alcohol and marijuana.
All right, so Mr. Marvin, is that correct? You wanted to proceed to trial?
Everything she said is correct. Sir.
All right, so Ms. Koch, you said how much time to be ready for trial?
We can set it out like 60 or 90 days, depending on the court schedule, and that would give him time if he decides to file that motion to suppress, to do so.
If I set this for trial in 90 days, is that enough time for you to be ready?
I would tell you, Your Honor, that I'd like as much time as I can. I don't feel like I'm going to have an issue as far as bond conditions or anything like that. And I don't have a secretary, you know, I've never done this. I'm learning every day as much as I can. And I do understand that I'm a one-legged man in a race against an Olympian. I understand that I am not going to become a lawyer by Googling it. you know, it is gonna, but the more time that I can have, the more prepared I could be. And like I said, I don't see an issue with anything to where that would change, and I am not requesting a speedy trial either.
Okay. All right, I think, you know, 90 to 120 days is probably what we would be looking at, so we'll set it out at that period.
Thank you, Joe.
Ms. Koch, how many days on trial?
1.
Besides yourself and possibly your wife, do you have any other witnesses that you would be calling?
I did have a question about that, Your Honor, and that's my brother, who I had talked to on the phone that day, he would like to know if he could write just what we talked about and not be present. He has fear of coming in, of repercussions, to be honest, and he would write that as well if that was necessary.
That's not typical. Usually witnesses have to be here in person to testify.
Yes, sir. Okay,
You could certainly try that. I suspect Ms. Koch would object, and I'd have
Fair
to make
enough.
a ruling on it.
fair enough.
So I can't tell you yes or no sitting here right now.
Yes, sir.
Because she could agree to it for some reason. So
Yes, sir.
that's a discussion that you should have with her.
Okay,
And if you want to introduce that kind of handwritten testimony at trial, again, I'm sure she would object, and then I would have to make a ruling at that time.
yes, sir.
Okay, so I'm going to set it for a one-day jury trial at about 90 to 120 days out. And so, Mr. Marvin, you'll get a letter from the court that gives you that trial date once we have that. I'm also going to set it for a final conference. And that's just, you know, one more opportunity for us to be in court to address any issues prior to trial. And to the extent that you would want to consider other or different plea offers, that would be the final date to do that. And then also the final date to file any motions. So that final status conference, you're going to get 2 different dates. You're going to get a date for the final status conference
And then one for the court
for the trial.
to try.
So that final status conference, if you have any motions, they all need to be set for hearing no later than that date.
That'd be for evidence as well, to get evidence in. or-
Yeah, any kind of motion that
Okay.
you would want to file.
Yes, sir.
And you're also going to get a copy of the scheduling order that explains to you all of those things.
Okay,
as well.
thank you.
And then there's also some instructions in there about providing witness lists and those kind of things. So just make sure you read through that, okay?
Yes, sir.
All right, Ms. Koch, anything further that we need to address for the record from your side?
I will amend the information. We did just get the marijuana lab to say intoxication by alcohol and or marijuana. And I'll send a copy of that to Mr. Marvin, and we can discuss any questions he has about the procedures that you set forth today. He'll probably email me.
Mr. Marvin, anything else I can address for your side?
No, sir.
Thank you, that's all for today.
Thank you. Thank you.
Okay, People versus Welch, case number 235271.
Afternoon, Your Honor. Krista McGregor on behalf of the people.
May it please the court, Michael Nichols on behalf of the people.
Set for a status conference today. Mr. Nichols, on behalf of your client. Statuses.
Thank you, Your Honor. We filed an appeal in the Michigan Court of Appeals on Friday. They've accepted it and assigned a file number. There are a couple of things I need to get to them though, by way of a signed order from the court. I filed a motion. I have the original in my hand for a stay. I have to ask the trial court for a stay before I can go to the Court of Appeals and ask for a stay if the trial court were to not grant the relief. As I see it, this is an issue that relates to the admissibility of evidence, critical evidence, and under MCR 6.126, I believe the court shall stay the proceedings unless it finds that the claim is frivolous. And I submitted a brief brief, laying out the definition of frivolous in the statute. So I'm asking the court for a stay. I do have a proposed order and an additional piece of information in the court's record.
Ms. McGregor, as to the stay.
Your Honor, our office would be objecting to the stay. I know it's in the court's discretion. I believe this case has had a significant amount of time. It was filed 14 and a half months ago. There's been numerous time to file motions and appeals. The prosecution has the right to a speedy trial in this matter. I think the delays have all been on the defense in this matter. There's been violations of bond during this period of time. And again, today, Ms. Welch tested positive for methamphetamine with your Crawford County Pretrial Relief Services. She also tested positive on May 14th, 2024 and June 6th, 2024. I'm not sure. I wasn't in those hearings. I know there was evidentiary hearing that was taken. I'm not sure why her bond wasn't revoked during those period of times, as I indicated, Mr. Curran covered those. I believe it's appropriate for a bond to be revoked when the bond itself is being violated. But in regards to this, I believe the people have the right to a speedy trial, and I'm asking, we could set it out. I don't think there needs to be a stay of proceedings. I think we can set it out with a date for trial. And there's been a plea offer that was offered in this matter that Mr. Nichols on July 5th, when I spoke to him via phone, asked if we would adjourn. I believe at the time it was status conference. There was a motion being held here. I wasn't here, Mr. Curran was, and we had a lab tech from Minnesota drive in that day. But I did talk to Mr. Nichols on the phone. He asked for an adjournment of that matter so he could have time to discuss the plea offer with his client, which I actually think was disingenuous, but that was to plead to count one and dismiss the second or subsequent offense notice. That offer is revoked, and I think it's time that we proceed to trial, Your Honor.
In terms of the positive, so there's a positive test today.
Yes, Your Honor, and I would be asking, I know, I didn't know if you wanted to finish the one, but I would be asking for the bond in this matter to be revoked. As I indicated, I wasn't here. I did file 2 ex partes in this motion that were set for motion hearing on May 14th and June 6th. She tested positive. July 5th, I think there was an agreement. As I indicated, I wasn't here. Mr. Curran handled that, but there was an agreement that she admitted to one of the bond violations, but we did have scientists drive in over the holiday, 4th of July, from Minnesota to testify in regards. They were arguing that the test wasn't qualified or quantified. But
none of that really, I mean, I just want to know what you're asking for.
I'm asking for a bond revocation, Your Honor, in this matter. Yes, this is her 3rd positive test during the pendency of the case.
Thank you. Your Honor, the presumptive positive is the way to classify where we are at now. I just spoke with Ms. Welch about it when she arrived at court 10, 15 minutes ago. And it will be sent to the lab. Premier Biotech is the lab. The court may recall the issues and arguments. And I'm going to contact their attorney, who's actually in East Lansing, and talk with them about making sure the isomeric ratio test is performed to try to distinguish methamphetamine from maybe over-the-counter consumption of perfectly legal products from what appears to be manufactured methamphetamine, which would be a violation of the court's bond. And I haven't even seen what the prosecutor is referencing in terms of presumptive positive. I know about it because my client told me about it. So it's very true what the prosecutor just said. If the court takes action which leads Ms. Welch to be incarcerated, speedy trial is going to become a completely the elephant in the room. The calculus will change for us, and we're going to want to have a trial as soon as we get out of the court's docket. The court rules and statutes that would apply if she is incarcerated pre-trial. So that's a fair point, because it's going to work both ways if somehow she, Ms. Welch, ends up incarcerated.
All right.
And I'm sorry, if it wasn't clear, I'll persist in the motion for a stay. I think I'd like to see what happens with the analysis from Premier Biotech.
Give me a couple minutes. Okay, we're back on the record, People versus Welch. So first of all, with regard to the stay issue, I just wanted to take a minute just to look at the court rule and the case law supporting it. And having done that, and despite the people's objection, I don't think the court has discretion. And it is an issue involving admission of evidence, which it very clearly is. And so, under normal circumstances, I might delay ruling on the motion to give the people a chance to respond in writing if they wanted to, but I mean, just looking at the court rule case, I just don't think there's much basis for objection. So the court is going to grant the motion for stay. Mr. Nichols, you provided an order along with the motion which the court will sign. With regard to the bond issue, this is Ms. Welch's third positive test, regardless of how those have been dealt with by the court and by the people in the defense. That this is the third positive test. And so I think pursuant to 6.106 and I2, Ms. Welch has failed to comply with the terms of bond. Again, this is the third positive test during the pendency of this case, regardless of the resolution of the prior two. It's the third positive test, which is a violation of the bond, one of the bond conditions that she not use or possess controlled substances unless prescribed to her. And then I think it violates bond because she's continuing to the extent that those positives are the result of use or possession, or it has basis to find that she's continuing to commit crimes and using and possessing methamphetamine. To the extent that defense takes a position that this is false positive or resulting from the use of other substances which are permissible over the counter and so forth. I mean, again, this is Ms. Welch's third positive test. I would think if she hadn't learned by now, she would be very careful not to use substances that could result in false positives. But she keeps testing positive. So I find that it's much more likely that those positive tests are the result of her use of methamphetamine and not by continuing to make mistakes and use substances which are resulting in false positives. So I think there is a basis to revoke the bond order that Ms. Welch's bond be revoked, that she be remanded to the custody of the county pending resolution of the case. So in terms of scheduling, Mr. Nichols, I'm not sure where that leaves you. The court's willing, of course, to get a trial date as quickly as possible. Is that your request?
It is. I drove up here wanting one thing and now I want something completely different on behalf of my client.
Understood. Ms. McGregor, is there a particular period of time that the people are going to be prepared to go forward to trial in this case?
No, Your Honor. I mean, we could be ready in 30 days.
Okay.
Well, I don't think they're entitled to 30 days. I think she gets priority on the court's docket. It seems that they can get a trial set. Absent an older case. That's
Well,
in custody.
I don't think I can schedule a trial more than 28 days out. The court rules I can do that. So the court will provide the next available trial date. Ms. McGregor, how many days of trial?
I believe it would just be one day, Your Honor. Mr. Nichols might think two.
I think with the felony, we should shoot for 2, and it's better to under promise and over perform, as they say.
Okay, so we'll set it for a 2-day trial at the court's next available date. Ms. McGregor, any other scheduling matters to address with your side?
No, Your Honor.
There were 2 evidentiary issues that I don't think were resolved, and that was, if the court recalls, she was in the back of the car in custody, and I argued that she didn't validly waive from Miranda, and I'm going to oppose that statement with, it was now Detective Sergeant Padlo that she made, if the court recalls that.
Mm-hmm.
And then I think it was also Detective, I read the transcript again when I was putting the appeal together. He said something about her making a statement at the jail, which I'll talk to Ms. McGregor and Mr. Curran about, but I mean, I'm gonna oppose that if she is in custody and there was not a valid waiver of Miranda and they wanna use it to try to prosecute her.
You know, I don't recall those being issues that were, I know that they were discussed and mentioned. I don't remember those being part of a motion that required a ruling by the court.
Yeah, definitely, because I didn't realize the jail thing was gonna come up until we started to testify to at the hearing on August 15th. But we definitely raised the issue of what she said in the car, and I said that was not a valid waiver, and that could not be used. And at that point, it could not be used for the calculus of whether or not the search was constitutional under an exception to the warrant requirement. But obviously, I'm going to argue that they can't use it at trial. I'm arguing it can be used by the court to consider the admissibility of her statement for the search and seizure issue.
Your Honor, I'm going to be perfectly blunt. I didn't bring all the motions today. I thought those were all resolved. I hadn't seen anything that said otherwise. So in regards to that, I guess if we're going to bring up more evidentiary issues, I don't think we could be ready for trial in 30 days significantly. If we're,
All right, Mr. Nichols, I mean, my recollection, and I can go through the motion, we'll do that before we leave here today. My recollection was, you know, your motions were to suppress the methamphetamine that was found, that evidence. The motion wasn't specifically to exclude statements that Ms. Welch had made.
To the extent that they were using those statements to say that they had probable cause, which is how I read their response to the motion. They were saying she made a Mirandized statement that gave the officers probable cause to conduct a warrantless search of the vehicle. That was what they argued. And so that's why I fleshed that out, put it in my post-hearing memo and also in the Court of Appeals. I think I fleshed that out pretty thoroughly and pretty fairly and said, hey, I object, this needs to be resolved. And I read the opinion in order 3 times. I didn't see that was addressed by the court.
Right. It wasn't because I didn't think that the statements were an issue in the search. I thought the search was justified for the reasons that indicated, regardless of whether she made statements or not. So to me, that's a separate issue than whether her statements in and of themselves are admissible against her trial. I mean, that could certainly be an issue, but then I agree with Ms. Greger. I mean, you had a hearing about specifically the statements that she made in the circumstances. There was some general testimony about that, but the court had to make some pretty specific findings about whether they were voluntary or not, so forth.
Yeah, it was Trooper Walsh. I think. That's where I ended my cross with him. Whether or not we went back and forth about whether she actually waived a Miranda, and you know, to me, that's an issue. If the court thinks that there was a waiver, I'd like to put that in.
I don't know whether there was or not. That's what I'm saying. Like, I think we would need to address that issue specifically.
Okay.
So.
And it puts me on the horns of a dilemma, right? Because she's going to sit in jail while we're hashing all this out. Now, I guess, why don't I talk with Ms. Welch, and I'll get with the court and with Ms. McGregor about trial now or motions on the statement first.
I mean, I think I can, honestly, Ms. McGregor, I mean, I don't think this is the type of motion that's going to require months of time to be prepared. I mean, I think I can easily get a motion hearing date prior to the trial date, even if that's relatively soon to get some decided without delaying.
And that would be appreciated.
and I guess I know we're jumping all over, but I want clarification. We just ordered a state of the proceedings is now in regards to that, it was granted, but now you're asking for it not to, I just want clarification. So we're not back on the record.
Absolutely.
Okay.
Yeah,
Okay.
based on their request for the court to schedule this for trial, I'm taking that as a waiver this day.
Okay. I just wanted clarification, just so we all were on the same page.
Okay, so what I'm gonna do, the court's gonna set the trial date. I'll send that out to the parties. I'll set it for a final status conference prior to that trial date. And we can have the motion hearing at that time. If Mr. Nichols, if you want to get a date sooner than that, just contact my office. I'm sure that we can get status on this watch. Thank you. That's all for today. Ms. Welch, your manager. I see your comments.
Thank you, Your Honor. Have a good day.
Mr. Lovely present.
He is.
Mr. Lovely, if you can forward. We're on the record in People versus Michael Lovely, case number 225137, 245341. The record should reflect Mr. Lovely's present here in court today.
Sierra Cook on behalf of the people.
Michael Lovely on behalf of myself.
Okay.
Yeah, I believe we've come to a resolution in this matter. I don't know. You still have a copy of this, Mike. The offer is plea to count 1 attempt UDAA, so making count 1 an attempt, and count 2 MDOP 200 to 1,000. With restitution, we're working on the restitution amounts. We only have receipts as $826, so we're asking the court to give us 2 extra weeks. We're trying to find this owner of this truck to get the amount, so we could have the 1st January date for sentencing. Dismissal of count 3, larceny 200 to 1,000, and the head third notice. Mr. Lovely is going to enter that plea today. He's representing himself, which he has been throughout this case. And I'll turn the pretrial statement over to the court.
Okay, and then Mr. Gonzalez to the probation.
Spoke to Mr. Lovely about pleading guilty to count 1 and 3 of the violation that correspond with his plea to the new felony file. It sounds like that's what he wants to do.
Mr. Lovely, I'm sure we've gone through this before, but I need to do this with you pretty much every time that we're in court because you might change your mind at some point during the proceedings. Okay. And involving representing yourself. So again, you understand that you have the right to have an attorney present today.
Yes.
And at any other time.
Yes.
And that if you couldn't afford one would be appointed for you. You understand that?
Yes.
And you're asking to represent yourself.
Yes.
And you understand that if you had an attorney, that attorney could explain to you your options with regard to both of these files.
Yes.
And also explain to you in detail what the consequences of this plea that you're going to enter into today would be. You understand that?
Yes.
So without having that advice, you could wind up with a sentence that's way in excess of what you thought it was going to be because of the sentencing guidelines and so forth. There may be other consequences by pleading guilty to a felony, affecting your rights to carry a weapon and all kinds of other consequences aside from jail and fines that you might not be fully aware of that a lawyer could help explain to you. Do you understand all of that?
Yes.
Same thing with regard to the probation violation. You understand that there could be additional penalties for that as well.
Yes.
Again, a lawyer would be able to help explain how these 2 cases would work together and how ultimately all the consequences might factor in. And so you understand that there's a risk and that you could wind up with a more negative or a worse result for yourself by going forward today without that kind of advice.
Yes.
So, despite knowing that risk, you still wish to represent yourself.
Yes. I'm here for a reason. There's no point in. Right.
Okay, no, and that's it's your right generally to do that, but I need to make sure that you're doing that freely and willingly and voluntarily.
Yes, absolutely.
And that you understand that you have the right to have somebody help you with that if you wanted it. All right, so the court finds that your waiver of counsel is knowing and voluntary and unequivocal. And so I'm gonna go through, first of all, the new file that involves the charge of unlawfully driving away a motor vehicle as an attempt. The maximum possible penalty that you could face would be up to 2.5 years. Do you understand that?
Mhm.
And that the court could also suspend your driver's license.
Yes.
And then count 2, which is malicious destruction of property, that's a misdemeanor that carries with it a maximum penalty of up to 1 year in jail and or a $2,000 fine or 3 times the amount of the value of the property. Do you understand?
Yes.
With those maximum penalties in mind, what is your plea to each of those charges today?
Guilty.
And you understand that by pleading guilty to those 2 charges, that you're also going to be found guilty of violating your probation.
Yes.
Okay. And as I said, you could face additional penalties for violating your probation. And that could be all the way up to the maximum penalty on your underlying charge, which is up to 5 years. Do you understand that?
Yes.
With all of that in mind, what is your plea again to the probation violations?
Guilty.
So I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want to. You understand all of those rights.
Yes.
Can you tell me what's going to happen to those rights by you pleading guilty?
I'm waiving one.
Same thing with regard to the probation violation. You do have the right to have a hearing as to whether or not you violated your probation. You understand that?
Yep.
And you understand that by pleading guilty, you're going to be giving up that right.
Yes.
Has anyone threatened you with anything to get you to plead guilty to either of these cases today?
No.
Has anyone promised you anything other than what we said here in court today?
No.
Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you are actually guilty?
Yes.
So the information I have indicates this happened back in April of this year. Is that correct?
Yes.
On or about April 15th of 2024, did you take a 2021 GMC truck that belonged to somebody else?
Yes.
Okay. Did you have any permission from the owner to drive that vehicle?
No.
Did that happen here in Crawford County?
Yes.
And throughout the course of that incident, was there damage done to a fence that was on the property of the person that owned that vehicle?
I did no damage to no fence. I did damage to the vehicle.
Okay. And what kind of damage happened to the vehicle?
I drilled a hole in the gas tank and took the gas.
Doing that to the vehicle, would that have caused, do you have any doubt that that would have caused at least $200 in damage to that vehicle?
I'm sure. Yes.
Okay. And you did that on purpose?
Yeah.
And that happened in Crawford County as well?
Yes.
Ms. Cope, are you satisfied with the factual basis?
I am.
Are you aware of any threats, promises, or inducements other than what's been placed on the record?
No.
And are you satisfied that the court has complied with statute and court rule in taking this plea?
Yes.
All right, Mr. Lovely, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of each of those charges. The court will accept your guilty plea as to both. At the time that all of this occurred, were you on probation here in Crawford County?
Yes, I was.
And were you aware that one of the conditions of your probation was that you were to not violate any laws in the state of Michigan?
Yes.
The court finds that there is also a factual basis to support a finding that Mr. Lovely did violate his probation as alleged at counts 1 and 3. The court will accept the guilty plea to that as well. We'll set this matter for the sentencing hearing set in January.
Can we have the first week of January?
Do you have any objection to that?
No.
Set it for a sentencing hearing in the first week in January. And you'll meet with Mr. McCullough for a recent report on all of those issues.
No, thank you.
Any questions?
If I could receive the restitution amount, at least 2 weeks before my sentencing date, that would be great.
Mike, just give me a call and we'll take a look and see where we're at. We're still trying to get the documents from the people we've been calling repeatedly. It's not
Okay.
lack of effort.
Okay.
Thank you, that's all. The court's after the docket.